Here.
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 Thank you. If we could all stand for the Pledge of Allegiance.
To the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good morning. I have some preliminary announcements to make before we commence. The First District Court of Appeals has graciously allowed us to use their facilities, so please respect their rules and have absolutely no food or beverages other than water in this room. Please also silence your cell phones. We have received some feedback from the public that sometimes it's difficult to hear the members and those before the commission, both in the room and over the live stream. Anyone addressing the commission, please make sure to speak up, speak into the long microphone at the podium so that you can be heard and so that your broadcast audio and recording equipment can pick up your comments. To my fellow commission members, please speak up into the long microphones on the dais so that comments and debate can be heard. If you share a microphone with another member, please pull it as close to you as possible when talking. Members, I ask that you be brief and concise as possible in your questions and comments, as we have a number of items for consideration today. Pursuant to Section 286.0114 Florida statutes, members of the public have an opportunity to have input on matters before the commission, other than in cases in which we act in a quasi-judicial capacity. This means that the public can have input on matters other than complaints, opinions, and determinations on financial disclosure cases. If you desire to be heard on a matter, please fill out a speaker card and give it to Ms. Fulford, excuse me, who has her hand up, all the way in the back. Thank you. Okay, let's move on to the first item on the agenda, approval of the minutes.
Move approval.
Second. Any opposition? All in favor, say aye.
Aye.
Motion passes unanimously. All right, first item is going to be item 4. It's been continued, I apologize. So item, do I need to make that announcement? Okay. So item 4A has been continued. We're moving on now to item 4B, consideration of motion to reconsider complaint number 22079. In complaint number 22079, In re Randolph Fine, the respondent has filed a motion to reconsider whether probable cause exists. Are the respondent or the complainant or legal counsel present in this matter?
Yes, Mr. Chairman, Richard Coates on behalf of Randy Fine and Representative Fine is here.
Thank you very much. Is there anybody else here on this case?
No.
Thank you. We have the record in this case in our materials, as well as a memorandum from our general counsel. Before I recognize Mr. Zukowski, sorry about that, are there any members who need to make a statement, disclosure in this matter? Yes.
I'm going to recuse myself for the appearance of bias and prejudice because of the complainant and both parties. I'll just put that because of both parties.
Okay. Thank you.
Mr. Chairman,
Yes.
I serve with Representative Fine, but it won't impair my judgment in the case.
Thank you, Commissioner Newton. Mr. Zukowski, you are recognized.
Thank you, Mr. Chair. Commissioners, you have a memorandum for me in this matter, and I just will cover it very briefly. In the memorandum, I let you know that you have before you a motion to reconsider whether probable cause exists. So this consideration before you really has 2 parts to it. The first part of it, you will consider whether or not you will grant the motion or deny the motion, meaning whether or not you will or will not reconsider probable cause in the matter. If you vote to deny the motion, that will mean that you will be sending the case back to the Division of Administrative Hearings, where the matter will be held for an evidentiary hearing, or perhaps a settlement might be reached before then. If you grant the motion, then you will have several options as you reconsider probable cause. You can continue the matter to allow for further investigation. You can direct your staff to conduct further investigation into the matter. You can find no probable cause. You can find probable cause, or you can take any other action that might resolve the matter. That would include finding probable cause but taking no further action on the matter, or issuing a dismissal if you believe that that is warranted. With that, I'm available to answer any questions, or I can step down to allow the presentation of the motion.
Anybody have any questions?
Thank you,
Yes, Mr. Darrell.
Thank you, Mr. Chair. So is there a standard of review for this first level of question that the commissioners should be mindful of?
Our rules don't provide for one. It's just, there is no prescribed standard here.
Thank you.
Thank you. Any further questions? Oh, sorry.
To follow on to that, do you suggest that the standard that would apply in a civil matter is a reasonable standard to apply to this, meaning that there would be some materially different facts or law that would impact the previous decision?
So you are free to make the decision that way. We would, I think I have some concern about the precedent that it would set here if we granted this and there wasn't any new facts or any new anything new that was happening that required you to reconsider the probable cause, because then we would have perhaps every respondent filing this motion. So yeah, I think that you'd be right to apply a standard just like that, yes.
Thanks.
Yes, go ahead.
Thank you. You say nothing new. I wasn't here for the last meeting. So could you elaborate on that, please?
Sure. If there was new evidence, for example, that warranted a finding of no probable cause, let's say something wasn't available at the probable cause hearing last time, and you wanted to incorporate those new findings or those new facts into your consideration of the matter to maybe direct your staff to investigate and draft a new ROI, for example, that would incorporate some sort of those findings or investigate that angle, that would be an appropriate use of, that would be an appropriate action for you to take.
You also mentioned setting precedents. We deal with a lot of elected officials. What do you mean by that? With this reconsideration, you said it'd be setting the precedent? We deal with a lot of elected officials. Can you elaborate on that? What do you mean by that?
There's a lot of people in this commission who have been here for several decades. A lot of them, none of them can recall a time where we've reconsidered probable cause, where usually what happens is the probable cause is found, and then the matter goes on to DOA, and it's either settled or there's an evidentiary hearing. Usually it doesn't come back for reconsideration of that probable cause. So this would be treading some new ground here for us. The motion's appropriate to bring before you because we have jurisdiction over the matter because DOA relinquished jurisdiction. So when the motion was filed, we as staff had to put it before you, but that's where we are now.
Last question, Mr. You said DOA relinquish jurisdiction?
Yes.
But if we do nothing, we send it back to DOA? I'm a little confused.
Yes, so DOA had jurisdiction after the probable cause, and maybe I should go through the entire procedural history here. Maybe that would be of some assistance here. I outline a bit of this at the beginning of my memorandum here, but originally in advance of the July 2022 commission meeting, your commission staff, having received a complaint, we reviewed the complaint as we normally do for legal sufficiency. Your legal staff recommended that there was not grounds to find the complaint legally sufficient. At the July 22 commission meeting, however, the commission voted to investigate the matter instead. The commission then conducted an investigation, what we call a preliminary investigation under our rules, we issued a report of investigation. That report of investigation was reviewed by the advocate in this matter. At the April 21, 2023 commission meeting, the advocate made a recommendation of no probable cause in this matter. The commission rejected that recommendation and found probable cause to believe respondent had violated both Article 2, Section 8H2, which is the prohibition against disproportionate benefit found in the Constitution, and also Section 112.313, subsection 6, which is the prohibition against misuse of position. The commission ordered a public hearing in the matter as a result of the probable cause finding. I attached the minutes to the probable cause in this, onto this memo just to demonstrate what had happened at the probable cause hearing. The matter was referred to DOA. Proceedings at DOA were moving forward. The respondent, I believe, made a motion to relinquish jurisdiction to allow this motion to be filed here. DOA allowed the jurisdiction to be relinquished, and in the motion made a note that if they would expect the case to come back if we didn't proceed to dismiss the case or find some other resolution to the case here within our jurisdiction. And so that's where we are now. There's a motion before you to reconsider probable cause, and that presentation will happen shortly. You're correct to be concerned about that. Your staff is equally concerned. We don't have a rule for everything, unfortunately, and so sometimes when somebody does something that we've not anticipated, we won't have a rule for it. So there isn't a timeliness standard here. There isn't a standard for judging this motion, and not in our rules anyway. So we don't have a rule of general applicability here because that would be an unpromulgated rule. So the motion's before you. It's set for you to look at and for you to judge on its merits and to make a decision so that the case can move forward.
Thank you. Yes, go ahead, Commissioner Hall.
Thank you, Mr. Chair. When I relatively innocently asked the question about standard review, I guess I had assumed that there is a process in our rules for reconsideration. And if there is not, while I'm empathetic for what was been described in the motion, I'm just not comfortable in establishing a rule here that applies in this one case. I would ask, and it may not be the appropriate time yet, sure, but I would ask for staff to come back to us and consider whether there should be a rule for reconsideration. It would have timing, it would have standards, it would have all the things we expect from a procedural due process standpoint. But today, with what I'm hearing about our limitation and our rules not having that, my question to staff would be, if there was something that was fundamentally wrong that could be shown as the respondent alleges here, without a motion for reconsideration, what path would exist for remedying that wrong?
Under normal through the chair, under normal circumstances, if there were some sort of procedural irregularity with the commission's handling of the case, the matter would eventually reach a final order. And once final action was taken by the commission, then the respondent would be entitled to an administrative appeal at the District Court of Appeal. And then the respondent could make the case for that then. There normally is, it would be very unusual to have, for example, an interlocutory appeal at the DCA on an administrative matter. So instead, we are posed with this motion. But that would be the path to take, would be to wait for final judgment, final action, and then appeal.
So Mr. Chair, I'm comforted that there is a path. And based upon that, if it's appropriate, I would move that, yes, sir.
If you can just wait for Mr. Coates to give the presentation before we put a motion on the.
That's fine, but my focus is on a procedural standpoint and not on the substance, but I understand. Thank you.
That's fine. And just real quick, with respect to what Commissioner Lau brought up, if there is an issue with the underlying, let's say, the procedure, the manner in which, let's say, a due process issue, that could be raised in DOA, correct? I mean, those matters are relevant once you're in front of an administrative law judge, correct?
Absolutely. The DOA judge would be free to consider whether or not the matter is ripe to be before the DOA judge. and could make a recommended order on that, and then at that point, a recommended order would come back before this body for final action, and the issuance of a final order. So in the end, the matter would still end up before you.
Thank you. Any further questions? Oh, go ahead, Commissioner.
Yeah, I just, from your summation, and hopefully this will catch me up. Now, and again, I wasn't here. So staff received the report, like in the normal process. Staff investigated the report and then gave their findings to the advocate. The advocate, among staff findings, came back with no probable cause. So the probable cause came from up here in the testimony? I wasn't here, I'm just asking.
Through the chair, that's correct. What happened, there was a recommendation of no probable cause, but and as you've seen in other cases that you've handled, it's not probable cause or no probable cause until you vote and say it is. None of us down here have a vote on that matter, so when the commission reviewed the matter, it decided that there was probable cause by a majority vote.
I just want to be clear, because I hear the word due process going around, so, but thank you.
And just to make sure to state, I mean, it's in the record, but the panel that found probable cause was back in, I believe, April of '23, correct?
April of '23.
Right. Okay, thank you.
Thank you.
Mr. Coates?
Do we have to push any buttons?
I don't believe so, right? No buttons need to be pushed, no. I would be in trouble.
Mr. Chairman, members of the commission, Richard Coates on behalf of Randall Fine, here on the motion for reconsideration. Rather than the debate about some sort of a global situation, this case does have a unique set of circumstances in it, and that is, quite candidly, until the memo that was prepared by your general counsel was made available, Representative Fine had absolutely no knowledge that this particular complaint had been vetted and debated by the commission itself for 18 minutes during legal sufficiency. He did not appear, and we will concede he was not at the probable cause hearing. The reason he was not here was there was a no probable cause recommendation. He was carrying in the last committee of reference a #1 priority of the Speaker of the House of Representatives legislation, and based upon that, but I can assure you that if he knew that this complaint had been debated based upon what I read in the recording or heard in the recording, there's absolutely no way that Representative Fine would not have made himself available to you to answer your questions at the probable cause hearing. There's a very unique set of circumstances here because we don't get knowledge of those hearings of legal insufficiency because normally it just appears that they're adopted and they show up in a press report the following Wednesday. But in this particular case, it was vociferously debated for 18 minutes with numerous questions and staff defending the legal insufficiency, and the commissioner that made the motion to find it legally sufficient made the comment, well, let's do an investigation and see if anything comes of it. Well, the investigation was done, nothing came of it. Your advocate recommended no probable cause. As I stated, Mr. Fine was stuck in a committee, had no knowledge that this thing had been debated and that you had, with all due respect, that there was a sensitivity to the actual existence of the complaint by the commission as opposed to just staff. So in this very narrow case, I think a reconsideration would be warranted to allow you to explore those questions that maybe you might have asked had all things been somewhat different at that particular point in time. But we're here now, and he's here ready to answer any questions that you have. And with that, we would ask that you, on this very narrow case, reconsider, for those reasons, the finding of probable cause at an earlier commission meeting. Thank you.
Thank you, Mr. Coates. One quick question. So with respect to the initial time this came before the panel, before the commissioners, Mr. Fine was noticed to come here, just made the decision based on the fact of the advocate's recommendation?
That and the fact that he was in the committee meeting, and the critical fact was he had no knowledge of the tenor of the comments that had been made during an 18-minute debate on legal sufficiency by this body. It was the same body that was going to hear probable cause, and based upon the tenor of those comments, which I've listened to and he's listened to, there's absolutely no way he would have not been here. That was an exigent circumstance of which we were unaware.
Any questions?
Yes, and he's here, he'd like to speak after your question.
Mr. Coates?
Yes, ma'am.
You may not want to disclose the reason, but I'm curious, since timing has been raised as an issue, why was there a delay of 4 months between the DOA's relinquishment of the matter and the filing of the motion?
There was session, I'm trying to remember because it should be in the record, and I was dealing with then advocate Ms. Miller, obviously, who's not there, and then there was something that he had to.
Something got delayed, I had to speak.
He had to speak, he had a prior speaking, and then we had put it on or we had asked for a continuance, and maybe Ms. Stillman can help me here with my addled memory, but
I can help.
it wasn't on the agenda for the last meeting. That was the one we had targeted.
It wasn't on the agenda for the last two meetings. The first of the two was at my request. I was asked to present model legislation on anti-Semitism to a conference, so we couldn't do it then, and you all graciously delayed it. It should have been at the last meeting, and for reasons I don't think we know, it didn't make the last meeting. So there has been some delay, but I don't think there's no reason behind it. I think it's just things happen.
So I'm not concerned about when the commission heard it, and I'm maybe not right about the timing, but as you know, in a traditional civil matter, I think you would have 30 days to file a motion for reconsideration. And so aside from the timing of this was a matter heard a year and a half ago, I understand that it went to DOA, and DOA is what evidently triggered your desire to seek relinquishment and come back here. So why not file it in May of '24, 30 days after DOA relinquished jurisdiction? Why wait 4 months to file
I
a
thought
motion?
it was filed fairly quickly once the language was worked out. I don't know the delays because we were in negotiations with Ms. Miller. And she agreed to the motion. It was an agreed to motion. The current advocate, Ms. Hadley, I will not speak for her, but she has indicated that I was to represent to you that she takes no position on the motion. But the relinquishment and all of that was agreed to by the
No, not
prior
that. And I'm
advocate.
sorry to beat it. It is relevant to me. There's, again, I think some commissioners might be concerned about the timing of when probable cause was found, over a year ago, April 23. That is one timing issue. Another timing-related issue is, according to the motion to reconsider I'm looking at, it says it's received by the commission August 27th. And DOA, maybe, and that's what I'm looking at.
I know DOA was backed up because the legislature was on an earlier
But you were
thing.
controlling when you filed the motion to reconsider, and again, if I'm wrong, just tell me. All I was trying to do is get a calendar in my head. It was relinquished by DOA in April. So that's 4 months.
I was in negotiations with Ms. Miller. At this particular point in time, I'd have to go back and dig through emails and files to figure out what was going on, but we were in constant contact with the advocate over it.
I can only speak for myself, which is I've wanted this thing to be resolved. So it was not a desire on my part to drag this thing out. I don't know the details, but there's no desire to sort of
No, there was,
filibuster and drag it out.
I'd have to go back and look, Commissioner, but I know that we were in constant contact with Ms. Miller, and then for whatever reason it switched out. I'm not familiar with the reasons, and then the language was finally worked out back and forth and then filed. And she had agreed to the filing of the motion. It was an agreed to motion with that advocate.
Okay. Thanks.
Anything further?
I know there were delays, not to beat the dead horse, there were a lot of delays in this case because of that compressed legislative session, which backed everything up at DOE. It kept getting backed up because session went in March or January, as I recall. There were committee meetings, there were budgets, there were all LBRs. You're familiar with those. So there was all kinds of, there were inadvertent delays that were not intentional.
Commissioner Long?
Thank you. I see in the motion for reconsideration a reference to no clear and convincing evidence. Why do you believe that's the standard?
That is the standard. The first DCA has settled that. It's clear and convincing for violations of the ethics code. Here you've got two very competent staffs at two different agencies that have completely analyzed it, and the legal sufficiency analysis that was done by your staff is spot on. The advocate's recommendation was spot on the law. I just don't see you getting, I don't see clear and convincing with everybody that's looked at it so far coming to the conclusion that, yes, this is a political firestorm, but it is not an ethical violation.
Any further?
If I might,
Yes, go ahead.
is it acceptable for me to address you?
Yes.
Thank you. So I wanted to, I'm not used to being on the other side of the microphone, so thank you for the opportunity. I want to take a minute, though, because I think there's an important existential question before you all as an ethics commission today, and I want to try to put this in clear context for you, for your function and your role. A longstanding political opponent of mine, and frankly, I think as you saw, Commissioner Descovich, filed a political complaint against me 2.5 years ago. She didn't just file a complaint against me, she filed a complaint against a second elected official, apparently a very similar complaint. We were not aware, as my attorney said, that this commission analyzed the complaint and came to the conclusion that even if I had done everything that she had claimed was true, that it wasn't illegal. Now, that was brought to the commission, and I encourage you to listen to a very uncomfortable and awkward and largely inappropriate 18-minute discussion about that, in which one of the commissioners, who is no longer here, said, "I don't like Representative Fine's politics." He brings up bills that I have run. He talks about reading about me in the newspaper and watching me in the media. And he actually says, "I only want to find legal sufficiency on one of the two complaints. I'm okay with the other one, but this one I'm not." And your staff nobly 6 times in the 18 minutes tries to remind them and says, even if it's true, it's not illegal. And he says, "I don't care. I want him investigated." Now, that is not an appropriate use of government, but it is clearly not an appropriate use of a commission whose job it is to find appropriate ethics in government. This was an abuse of power, and we didn't have any idea. So a few months later, we cooperate, we meet with the investigator. Frankly, they say, "I don't really know what we're investigating," but we meet, we cooperate, and then they say, "Look, nothing, if you did it, it's not illegal," and it turns out you didn't do it. Not only did you not do it, but we've determined in the process of doing the investigation that the complainant made misrepresentations that they knew were false. This complainant had filed a similar complaint to a different state agency, the Department of Agriculture and Consumer Services, about, if you remember, there's a part about a private investigator, and found that everything that she had claimed was false. And she knew that at the time that she filed the complaint. So your staff, again, I guess apparently a separate staff, said, not only is it not illegal if he did it, he didn't actually do it. Now, we didn't come, and that was a mistake on my part that I accept full responsibility for. It wasn't a sign of disrespect, but we were told this isn't a big deal, it's going to get tossed. And I was down the road presenting a bill before the Appropriations Committee. Literally, while this was going on, I was presenting legislation. That's the only reason I wasn't here. It would have been easy. I was in town, unlike today where I had to drive here. And in a 3-minute conversation, the same individual says, if this was someone different, I would agree with the commission, but because it's Representative Fine, I want you to prosecute. And the reason that we're here today, honestly, and I don't know, maybe I shouldn't even be saying this, the reason this has taken so long is it's impossible to put a prosecutor in a position to prosecute someone when that prosecutor has on the record said you did nothing wrong. That's why this has gone around and around and around. Because we said, look, we're going to call you as a witness. You said I didn't do anything. And so that is why this has gone into this netherworld. And I think that is what brings us to why we are here. So the decision you all have is it appropriate for the Ethics Commission when staff comes and says, even if he did it, it's not illegal, we don't care, investigate. Well, we did investigate and he didn't do it, we don't care, prosecute. That's where we are. And I think the reason to consider this today is because if we go back to DOA, we're back in the exact same position, where the evidence that we will use to defend me is the evidence that this commission has created. I don't have to provide my own defense. You did it for me. And as stewards of public resources, this stuff costs money. Costs money for the state, it costs money for these people, it costs money for what you're doing today, and it costs money for me personally. Now, I'm very lucky. I had a successful business career. I can afford to pay him. But this shouldn't happen. It shouldn't happen to me, and it shouldn't happen to anybody. And so I think you have the opportunity today to actually make sure that this commission is acting in an ethical manner. And I want to be clear, almost none of you were here for that, and none of you were the individual who pushed this agenda down the path. But that person acted unethically, and you have the opportunity today to fix that. And I'm happy to answer your questions, but I hope you'll take advantage of that opportunity today.
Thank you, Mr. Fine. Any questions? If I can make it just, I'd like to propose a motion to deny the motion for reconsideration, and the rationale is I'm very uncomfortable disturbing a prior panel's PC determination, just from a procedural standpoint. And if the issues that you raised here today, sir, are accurate, then I think that the body you should be before is DOA, that these issues would be relevant to the underlying case. Notwithstanding or regardless of whether you were here on that day or not, it seems based on what you said here to this body that somebody here up in this dais was hell-bent on doing whatever they had to do. I don't think your presence may have changed that, notwithstanding counsel's argument, because my experience has been if somebody wants to do something, chances are it's going to happen. However, from a procedural standpoint, we don't have any rules, motion for reconsideration, there's some timeliness issues. And just on this case alone, notwithstanding of what it can do to any other cases, I don't think this is the proper venue for the.
Commissioner, I'd like to
Just
second the motion.
Point
and
of procedure.
I would like to
Point of
add,
procedure. Can the chair make a motion without surrendering the gavel? Or
No, I was,
Just a point of procedure. Can the chair
Yes.
make a motion? without
This commission
surrendering
is
the
not,
gavel?
through the chair, this commission has not adopted Robert's
Right.
rules or
Okay,
anything like
all right,
that,
I'm
so
just-
there's
I'm
no
just
formal
asking.
procedure for
Fire
that.
away.
I'd just like to add to the commissioner's motion, trouble that there's an accusation that the commissioner acted unethically. There should have been if there was an unethical action, there should have been a complaint that was brought. Trouble, hearsay statements, that are the basis for the motion. And I join the commissioner's concern, trouble by the request for second guessing what previous commission had done. I would point out to the movement that we entertain motions to continue the whole time, and motions to continue almost uniformly granted by the executive director. So those motions to continue are pretty much uniformly approved by the commission, but it's the commission here that makes the decision, not staff, not the advocate. The commission as a body makes the decision whether to find probable cause, and for that reason, I would support the chair of the commission.
thank you.
Got a statement on the motion.
Go ahead.
I won't be supporting the motion, and the reason being is that I often sat up here in my over 2 years of being on this committee, and numerous times, this committee has went way off path. I mean, we had a situation where the staff was saying that we have nothing else. We can't go anywhere else. And this commission wanted them to keep going. You heard the evidence That's the same evidence that's gonna be presented to that staff went out and find. Unless staff go out and find new evidence, something brain shattering, they're gonna come back with the same result. So this is gonna be a waste of time and a waste of money. That said, the commission does have that power. You're exactly right. But on numerous occasions, we have set precedents by trying to direct staff to do the impossible. Try to get them to encourage witnesses that are no longer participating in cases that probably was a year or 2 or 3 years old, with the threat of locking them up when they already been penalized once. We've done some stuff up here that I think numerous times shouldn't have been done. And I've probably been outvoted with it, but I won't be supporting this motion on those grounds alone. If you go on the evidence, if you go in the hearing, and I won't say that Representative Fine, I served with him, and I disclosed that in the beginning, but I won't say it was hearsay, because everything here is public record, and it's on the record. So you can go back and play it minute by minute, the whole 18 minutes of it. You can hear what everybody is saying, even me right now. So I have a problem with, and I was not here, but I have a problem with when staff go out and do their work, they do great work, I think. And then when they come back with a recommendation based on what they found per the complaint, which is the process. That's why I asked about due process from my attorney. And then we sit up here and we relitigate it and do different stuff. And unlike what is being alleged, it is times that people up here do have their opinions and they're objective and they push them in spite of what staff's recommendation. And you can go back and look at the minutes, you can go back and watch the YouTube videos, or you can go back and watch the Florida Channel. It's historic, and I often said, always said in precedents, and we asked staff to do the impossible. They got nothing. They got just what you just read. They got what they had back in April. And they're gonna get the same result.
Thank you, Commissioner. Can I have a vote on, all those in favor of the motion, say aye.
Aye.
Clarify.
Sorry, go ahead.
You made a motion to deny the motion for reconsideration.
Correct.
So I just wanted to double clarify that there's 2 layers of motions. So if you vote yes to this motion, you're denying Mr. Fine's motion for reconsideration.
Okay, then.
Everybody probably
Right,
knows that, but I
right.
just wanted to slow it down and make
Doubly
sure we're
knows.
speaking
Okay.
the same language.
Yes, to make sure that's on the record. Thank you. So all those in,
Okay,
so go ahead.
Sorry, I interrupted your vote because I just wanted to make sure people were saying what they meant. So,
All right.
can you restate it? I mean,
You want
can
me-
you call the vote? I don't know.
Okay.
I didn't vote yet.
Okay, all those in favor of the motion to leave the probable cause order from April 26, 2023 in place and undisturbed, say aye.
Aye.
Aye. But I think,
No,
just
you
technically
didn't.
correct,
sorry.
what you have to, your motion was the first time that I heard it, was you moved to deny the motion for reconsideration.
Correct.
So I just, that was slightly different than what was said the second time, so for the benefit of the record, I just.
Right, no, there's a motion to reconsider before this body. We're denying the motion to reconsidering, and when you deny it, obviously what stays behind is the April 26, 2023 probable cause finding. So just to make sure the record's clear on that. And again, let's just do the vote, just to make sure all those in favor say aye. Aye.
Aye.
All those opposed?
No,
That motion passes. Thank you. The next agenda item in this consideration is the advisory opinions. There are consideration of advisory opinions file number 2813 and 2814. Any public officer, candidate for public office, or public employee in Florida who is in doubt about the applicability of disclosure laws or standards of conduct to himself or herself, or anyone who has the power to hire or terminate another public employee, may seek an advisory opinion from the commission about himself, herself, or that employee. Advisory opinions are based solely on the facts provided by the requester and are legally binding on the conduct at issue. We'll first take up file number 2813. Is the requester in attendance?
Yes.
Can you please state your name for the record, please?
Yes, sir. My name is Thomas Bowen.
Thank you. Mr. Schaefer.
Thank you, Chair. This opinion request concerns one of the Commission's post-employment statutes, Section 112.313, subsection 9A4. Excuse me. The law applies to several different types of state, executive, and legislative branch employees, and what it does is after they leave employment, it places a 2-year prohibition on them returning to represent clients for compensation before the agency where they were employed. This particular inquiry is coming from one of the member service liaisons for the Florida House Majority Office, and as you just saw, he's here with us this morning. He's wondering, first of all, whether the 2-year prohibition applies to him. Then secondly, if it does, whether it will just prohibit him for 2 years from representing clients before the Florida House, or whether that will extend to the Florida Senate as well. Now, the first thing to take away from the draft is that the law does seem to apply to this individual's position. The statute lists the types of employees that are subject to the 2-year post-employment ban. It lists several different types of legislative staff members that are going to be subject to the statute. Now, if you take a quick look at the statute and you look at that list, you're not going to see listed there the member service liaison for the Florida House Majority Office. But one position that is mentioned is any analyst employed by the Florida House Majority Office. The employee here has confirmed for us that despite his title, the Legislature's Office of Human Resources actually considers him to be a legislative analyst. That's how they've classified his position. Because the legislature views him as an analyst, and because analysts in his office are listed as an employee covered by this 2-year post-employment statute, it does appear then that the 2-year prohibition will be triggered for him once he leaves his position. So the only question remaining then is how far does his agency extend? Will it just prohibit him for 2 years from representing clients for the Florida House, or will that extend to the Florida Senate as well? Well, this type of question hasn't been raised by legislative staff members too often in the past, but when it has, the Commission has taken kind of a one-size-fits-all approach to determining the agency of a legislative staff member for the purpose of this 2-year post-employment law. So you can read in the draft, we've issued opinions to House and Senate committee directors and deputy committee directors. There's actually 2 opinions doing this, indicating their agencies are the entirety of the legislature. But I will say those are fairly short opinions, and the only authority cited by the Commission in those opinions are past opinions issued to actual legislators, finding that the agency of a legislator encompasses both the House and the Senate. Now, perhaps these opinions to the director and deputy directors over there at the legislature, perhaps they were properly decided in terms of their outcome. And it's very possible the level of influence that a committee director or deputy committee director has at the legislature justifies treating both the House and the Senate as their agency for the purpose of this law. But that's not going to be the case for every staff member covered by the statute, and I believe this requester is a good example of that. From what he's told us, his responsibilities are limited to monitoring the news and social media, summarizing bills and amendments, and preparing graphics and publications for use in the House. He's told us that he has absolutely no contact with Senate members or Senate staff, and to be honest, even when his office interacts with House members, it's usually done by his director or deputy staff director. So this is an individual with really no influence outside the House, and to expand his agency beyond the House doesn't really reflect the reality of his position. Now, in other cases involving other state departments, what the Commission has done is that it's found it appropriate to break a department down into its smaller units when trying to figure out what a staff member's agency would be for the purpose of the statute. Now, that's based on how the Code of Ethics defines the term agency. If you look up the definition of agency in the Code of Ethics, you can find that it breaks a department down into its individual divisions and bureaus. And so the Commission has found in the past that one's agency, for the purpose of this 2-year prohibition, is just the particular division or bureau or the unit where they have influence, as opposed to the entire State Department itself. For instance, I wrote in the draft some examples of this. For example, former employees of DOT, we found their agency for the purpose of this statute is just the DOT district where they're employed, assuming they don't have any influence elsewhere. We've also found the agency of a Department of Health former staff member to be only the departmental unit or board where they worked, not the entirety of the Department of Health. Now, for some reason, the commission has never applied that logic to legislative staff members. I think probably because, like I said before, these questions aren't usually raised by legislative staff members. But it does seem appropriate to kind of take that individualized approach, and it would be consistent with how the commission has treated the agency of those employed by other state departments. For that reason, the draft in front of you recommends you take that individualized approach to this employee. Based on his responsibilities and his limited level of influence at the legislature, we're recommending you find his agency to be just the House, because he has no contact with the Senate or any members or staff of it. So this means he'll just be prohibited from representing clients or compensation once he leaves state employment for 2 years before the House, but he will be able to represent clients before the Florida Senate within that 2-year period. I'd like to emphasize 2 things before I close. First, just because you might find this particular requester's agency to be only the House, that doesn't mean that other legislative staff members that are mentioned in the statute will across the board have the same result. What the draft is saying is that each staff member's position must be examined so that we can determine the extent of their influence at the legislature. If they have duties or contact with the other chamber, their agency may end up being both the House and the Senate, regardless of what you find for this particular individual. And second, I want to close by noting the purpose of the post-employment statute. It's there to make sure that state employees aren't leveraging the influence that they have at the state for private gain once they enter the private sector. It doesn't appear this draft, what we're recommending here, is counter to that. The draft's just recognizing this employee has no authority to leverage at the Senate. He has no contact with it. So it doesn't seem equitable then to include the Senate as part of his agency. So I offer this draft now for your consideration. I'm happy to answer your questions.
Anybody have any questions for, yes, go ahead, Commissioner.
Mr. Shaker, so in making the recommendation for the opinion, you're making a distinction between a staff member and a legislator, and in terms of both the responsibility that they might have, as well as the influence that they might have, as well as the scope of their communications.
Exactly, Commissioner. You know, and through the chair, I would say that there may be other staff members mentioned in the statute that have significant influence in both chambers. And this draft doesn't mean that they would just be limited to one chamber then. What we're just saying is that for staff members, we've got to take a closer look at their level of influence over there before we just flatly say their agency is both chambers.
So rather than take a completely broad brush approach, you're trying to take a more narrowly curtailed approach.
Yes, sir.
To that specific staff. Thank you.
Any further? Yes, go ahead, Commissioner.
Thank you. And following up on Commissioner Bain's line of questions, it sounds like you're suggesting that we should do a qualitative approach, how much influence somebody has.
Yes.
And so that would perhaps mean that if you have somebody from the minority party who has never passed a bill, maybe that person would be considered to have no influence, and this law shouldn't apply. And the point I'm trying to make is I'm troubled by asking us to make qualitative analyses here. And it seems like the law is written in a way that has pretty clear distinguish. And we historically have said the agency is the entire legislature. So I'm troubled by the concept of issuing an opinion that will expect us to determine how good somebody's influencing abilities have been, if that's what I understand you to be saying, and how we apply the law.
Through the chair, my only comment to that is what the draft was recommending is not necessarily looking at how effective they've been in the performance of their duties, but just what are their actual job responsibilities, and do their job responsibilities require them then to have contact with the opposite chamber? And it just seems for this particular individual, his job responsibilities are just at the most confined to the Florida House. He has no contact with the Florida Senate. I think that if we're talking about an actual legislator, the draft really doesn't address that. You know, this draft is just narrowly tailored to looking at the legislative staff members that are enumerated in the statute.
Yes, Commissioner. I'm sorry, are you finished, Commissioner? No further questions.
Before I ask my question, I want to thank Mr. Bowling for the opinion. Your request for the opinion, it was well-written, and I don't know how old you are, but usually member services liaisons are younger, and I think you're going to thrive just based on the way you wrote it, as well as having the sensibility for requesting the opinion, given how others have interpreted it. So thank you for that. And thank you for your opinion, Mr. Schaefer, which, you know, I agree with almost 100% of the time. Today, a little bit wobbly as well on the what has been described as a qualitative evaluation that we may be making in the future, because even though this only applies to the employees, not to the legislative member, I'm still concerned that there is the possibility that the scope of influence is not necessarily defined by the title. That a person who is a member services liaison can still have outreach depending on what his boss wants. I mean, you could you could have a page who's, you know, 14 years old, interning, do something or have cause to do something that's influential. So I just don't know that using the title and even asking the person, what do you do? Well, you know, that may be what is described on their job description, but doesn't really talk about subjectively what their scope of influence is and their reach. Even without influence, what is their reach? Because they are two very interactive bodies constantly in fluid motion.
May I, through the chair, may I address Commissioner Anker's concerns? I do understand what you're saying. There's two things that I would like to point out. You know, again, I'm not just basing this on his title. You know, if you look at question number 4 that I asked him, which is in your agenda items, I asked him, do you have any responsibilities that require you to interface with I'm just trying to find the exact question here.
And I don't mean title while you're looking for it as much as what one's title
Sure.
describes the responsibilities are and what one says. And for Mr. Bowling, I accept at face value, those are the definitions of his job, and that's actually what he does. But I'm not sure that that is the case all the time.
The two things that I would like to mention, I don't know if this will alleviate your concerns or not. Question 5 is the question I was thinking of. Do you have any responsibilities that require you to interface to any office or unit within the Florida Senate? And his answer was, none come to mind. Now, I understand that that is what he is saying, and that conceivably some situations may arise where he may occasionally have contact with the opposite chamber. The two things I'll say to that is, first, the Commission has clearly stated in the past that minimal contact with employees of another state department do not mean that that other department is part of your agency for the purposes of this post-employment statute. We have said that several times. I will also again point you to what the Commission has done for employees of other state agencies. As I mentioned in my presentation, you know, someone at the Department of Transportation may occasionally have contact with employees from other DOT districts, but the Commission has clearly found that if their influence doesn't extend there, or they really don't have any substantive responsibilities, they're not working on any projects of the other district, their influence is just limited to the particular district where they're employed, that is their agency then for the purpose of this post-employment statute. So what I'm recommending here is just reflective of what the Commission does for nearly every other state department.
The legislature probably does get tainted with, you know, there's more movement and more activity, it appears, you know, they're working for the elected officials, not ones that are appointed. So it just brings to mind, to me, some concerns. But I appreciate that it is aligned with other agencies, the way you've described it, like DOT and the regions. I mean, I think that's a good example that makes our decision, for me at least, a little bit more challenging.
Yes, go ahead, Commissioner.
Clear that the recommendation for the opinion only applies to staff, it doesn't apply to legislators.
That's correct.
So that distinction needs to be very comfortable.
Any further comments or questions? Is there a motion or some?
Move to approve the opinion?
Is there a second? Second. All those in favor? Aye. Opposed?
Halfway nay.
And I'll take her other halfway. Because I'm expecting Commissioner Anker feels like I do, if I can just bear with me a minute.
That's good.
We applaud what you're doing and what you want to do, and we want to wish you the very best as you proceed. So I want to have a path that you can go forward, but you do refer to looking into the amount of influence that a person has, and that feels qualitative to me. So I don't know how you're going to apply this in the future, but there's my halfway yes or nay.
And thank you for the half. And again, I think it is entirely supportive, and you're going to have the votes you need to move forward. The only reason I'm making a post-vote comment is because if I vote against an advisory opinion, then I like to have a suggestion or a different analysis or additional language, and I don't have that, other than to say that it is too much of a subjective evaluation to make on a recurring basis for members of legislative staff. Which is why I only could vote halfway no.
Yeah, I'm just wondering how I do the math.
Yeah, it passes.
But, so given the count, the motion passes. Thank you very much. Of course, I'm chair and I got to do math. Great. Yes. The next advisory opinion is going to be file 2814. Is the requester here? No. Are there any members that need to make a disclosure? Mr. Sokowski, the podium's yours.
Thank you, Mr. Chair. Commissioners, Robert Klusik is the requester of this advisory opinion. The requester is a man who wears many hats. In his official capacity, he is currently a member of the Board of Supervisors of the Ave Maria Stewardship Community District, which is an independent district in Collier County. There are 5 seats on the governing board of that district. 3 of them are selected by the landowners on a 1-acre, 1-vote basis. 2 of them, including the requester's seat, are elected by the qualified electors of the district. Until recently, the requester wore another hat. On September 30th, 2024, the requester vacated an appointed board seat on the Collier County Planning Commission, which is an advisory board to the Collier County Board of County Commissioners. In his private capacity, the requester wears a 3rd hat. The requester is an attorney, and as part of his practice, he seeks to represent clients before the Collier County Planning Commission and the Collier County Board of County Commissioners on land use matters that might come before those 2 boards. Those representations would most likely include seeking exceptions or deviations or waivers on land use matters. In his request, he asks whether he may represent his clients before the board he just recently left, the Collier County Planning Commission, and the board it advises, the Collier County Board of County Commissioners. To answer that straightforward question, the draft undertakes an analysis of 3 laws. The draft starts with the post-office holding representation ban found in section 112.313, subsection 14 of the Florida statutes. That law prohibits local elected officers from representing clients before their government body or agency for compensation for a period of 2 years after they vacate their office. The draft concludes that this law does not currently restrict the requester because he did not vacate an elected office. And he is currently not a former elected officer. His former board, the Collier County Planning Commission, is an appointed board. On the other hand, it is his current board, the Ave Maria Stewardship Community District, that's an elected board, but again, he's not a former member of that one. The draft also looks at the constitutional prohibition commonly referred to as the post-office lobbying ban. This prohibition was proposed by the Constitutional Revision Commission and approved as an amendment to the state constitution in 2018 by referendum. It became effective on the last day of 2022. It prohibits certain public officers from lobbying for compensation before certain enumerated agencies for a period of 6 years following their vacation from office. As it pertains to enumerated local public officers, they are prohibited from lobbying their former agency or governing body. There is a list of officers to which this prohibition also applies. The draft details those. The requester's former office at the Collier County Planning Commission, however, is not among the ones listed. So again, the post office lobbying ban does not currently restrict him from representing or lobbying in his capacity. If those were the only two analyses that we needed to do, your staff probably would not have suited this up for a formal opinion. We could have advised the requester all of this informally. There is, however, a third analysis that is slightly more complicated, and this is probably why we brought this before you. The draft analyzes the requester's inquiry under what is commonly referred to as the in-office lobbying ban. Like the post office lobbying ban, this law became effective on the last day of 2022 and became an amendment to the state constitution after being proposed by the Constitutional Revision Commission. The in-office lobbying ban prohibits certain public officers from lobbying for compensation before the federal government, the legislature, any state government body or agency, or any political subdivision of the state during his or her term of office. Among the several public offices to which this restriction applies, it applies to, quote, an elected special district officer in a district with ad valorem taxing authority. In order to figure out whether and how this restriction applies to the requester, the draft looks closely at several terms that were defined in the implementing legislation that passed after these referendums were approved by the voters. The draft concludes that the in-office lobbying ban generally applies to the requester because he meets the definition of an elected special district officer in a district with ad valorem taxing authority. That's a defined term in section 112.3121, and the draft details that analysis. That means that the requester is generally subject to the prohibition of the in-office lobbying ban. What is prohibited in the in-office lobbying ban is lobbying, and the word lobby is also defined in the same statute. The relevant part of the definition of lobby is, quote, to influence or attempt to influence an action or decision through oral, written, or electronic communication, and with respect to a political subdivision, is limited to influencing legislative actions or other discretionary decisions, but does not include administrative actions. In other words, the definition of lobby carves out administrative actions and makes administrative actions not subject to the restriction. Administrative actions are also defined in 112.3121, and in the relevant part, it is said that administrative actions are, for a political subdivision, not subject to Chapter 120, any action or decision on a license, permit, waiver of regulation, development order or permit, or development agreement, and also any quasi-judicial proceeding on local government land use matters regulated by Section 286.0115, subsection 2. The draft takes you through this, but the procedures of the Collier County Planning Commission are regulated by Section 186.0115, subsection 2, and the actions the requester seeks on behalf of his clients are, according to him, mostly waivers. Thus, for two reasons, the draft concludes that the client representations the requester seeks to undertake meet the definition of administrative actions and are not included in the definition of lobby. Therefore, the draft finds that although the requester is generally subject to the in-office lobbying ban, the conduct that he proposes to engage in is not prohibited. In conclusion, the draft stands for the proposition that none of the three prohibitions would restrict the requester from engaging in client representations he describes in his inquiry. I present this draft for your consideration, and I am available to answer any questions you may have about it.
Thank you, Steve. Any questions, comments? Is there a motion, or can I get a motion?
Move approval.
Second.
All those in favor?
Aye.
All right. Any opposition? Hearing none, passes unanimously. Thank you. Item number 7, consideration of rulemaking. We have two rule hearings on our agenda today. The purpose of a public hearing is to allow the commission to hear public comment, evidence, and argument about the proposed rule or proposed changes to an existing rule. Following the public hearing, the commission will decide whether to make any changes in response to public comments or written materials received, or whether to accept the rule as noticed. The commission may withdraw a rule in whole or in part or may make such changes as are supported by the record of the public hearing or any written materials we have received. The commission may also make technical changes which do not affect the substance of the rule. I'll ask Mr. Gray Schaefer, who presented the draft items, to explain the rules and put us in the proper posture. And then we'll proceed with the public hearing, deliberation, if any, and vote. Thank you, Mr. Schaefer.
Thank you, Chair. Commissioners, this first rule hearing pertains to Rule Chapter 34-7 of the Florida Administrative Code. Now, that's the rule chapter where different commission forms and the instructions for completing those forms are incorporated by reference. Whenever we amend a form or its instructions, we have to go through this rulemaking process and have you re-adopt the amended forms. That's why we're here this morning. The particular form that this first rule hearing pertains to is the Form 50, which is the ethics complaint form. Now, that particular form, we have statutory authority to promulgate it at the Commission, and it's incorporated by reference into Rule 34-7.010, subsection 1B. Now, the current Form 50, which is incorporated into that rule, is 6 pages long. It can be found at pages 8 through 13 of your meeting materials for this agenda item. The amended Form 50, which we're asking that you adopt today, is only 2 pages long, and that can be found on pages 6 and 7 of your meeting materials. There's 2 main changes that we're proposing here this morning, and let me talk about the most obvious one first, which is reducing the Form 50 from a 6-page document to a 2-page document. If you compare the first and last pages of the current complaint form, that would be pages 8 and 13 of your meeting materials, and you compare that to the 2-page amended form that we're proposing on pages 6 and 7 of your materials, you're going to find that they're largely the same. The first page of both the current and the proposed amended form gives specific instructions on how to actually fill out the Form 50. And then the last page of the forms is where you put down information if you're the complainant about yourself and your address. You put the name, position, and address of the respondent, and then there's the portion for the complainant to fill out with a notary. We are keeping those pages of the form largely the same. Really, in the amended form, on those pages are just proposing a slight reformat, just aesthetically. We're reformatting some of the text so it's in boxes. We're removing the Ethics Commission seal, but largely the content on those pages is going to be just about the same. Now, that leaves pages 2 through 5 of the current complaint form. That'd be pages 9 through 12 of your materials. We're proposing removing those 4 pages from the Form 50. Those 4 pages don't provide specific instructions on how to actually fill out the form. Instead, they just give general background information on the Ethics Commission, like the laws we have jurisdiction over, our statute of limitations. They give general instructions on how a complaint works through the commission process, the fact that it's investigated, goes to the advocate who makes a probable cause recommendation. If probable cause is found, it could go over to DOA. And those 4 pages also have a comment about our attorney's fees law. This information is definitely good background, but it's not necessary to actually completing the Form 50. And we think that it makes the complaint form more intimidating to people looking to file an ethics complaint. Because instead of a short 1 or 2-page document, it's now essentially 5 pages of instructions, only a portion of which are actually needed to fill out the complaint. So what we're proposing is removing pages 2 through 5 of the current complaint form and putting that general background information up on a web page where anyone can read it. And we'll hyperlink that web page in the first page of the amended form. Now, I want to emphasize this is not an attempt to circumvent the rulemaking process by putting material up on a web page that should have gone through rulemaking. All of the information being removed is just general background information on the commission that is already covered in pre-existing laws and rules. And a good chunk of that information is going to stay on the first page of the amended complaint form that we're proposing. I also want to emphasize those pages are taking out, again, it's just general background information. They don't impose any requirements on anyone because that certainly would have to go through rulemaking. We just think that removing those 4 pages make the complaint form more accessible and easier to understand for filers. So the first change here is just reducing the length of the form. The other change is more technical in nature. As you know, during this past session, the legislature amended the ethics laws to require that an allegation can now only be found legally sufficient for investigation if it's based on personal knowledge or information other than hearsay. We think we need to insert language in the complaint form notifying complainants of that. So we're proposing adding a bullet point on page 1 of the amended form, reminding filers that a commission can now only investigate an allegation based on personal knowledge or information other than hearsay. On the second page of the amended complaint form, we're just adding a short phrase asking that complainants fully explain how they became aware of the allegations that they're bringing. We think that this reflects this new change in the law and brings the complaint form up to date with where the law is at currently. So those are the amendments we're proposing with the Form 50. I'd be glad to address any questions you might have about them. I will say all these changes have been duly noticed, publicly noticed in the Administrative Register. We also provided the amended form to JAPC for it to review. And I know I've mentioned this before, but for those of you who don't know what JAPC is, it's the Joint Administrative Procedures Committee. That's a legislative agency that reviews proposed rules coming from agencies to make sure that the agency has authority to promulgate the rule they're proposing. I gave the amended Form 50 to JAPC about 3 weeks ago. They've had no feedback they provided, which I take it to mean a good sign that they're comfortable with what we're proposing. So if you adopt the amended Form 50 today, the only step remaining will be to submit it for adoption with the Department of State. So I submit the amended form to you now, and I'm happy to answer your questions.
Thank you. And there's no public comment on this? No? Thank you.
I got one.
Okay, go ahead, Commissioner.
You always refer to JAXI and you send the things up there to them. Have they ever responded back?
Yes, they have, occasionally. When we did rulemaking on the disproportionate benefit amendment in the state constitution several years ago, I believe we got extensive feedback from JAPC.
Okay, I thought they were just a hypothetical group.
No.
As an attorney, when I was at the Department of Corrections and we did rulemaking there, we received feedback from them very regularly.
JAPC also has to
offense,
certify,
no
JAPC has to, if you would accept the proposed rules that we're offering, I have to notify JAPC you've accepted it, and it's a prerequisite that JAPC has to certify the rule amendment to the Department of State in order for the rule to be officially adopted. So that's what happens after you vote on a rule amendment.
So it's a box to be checked.
Yes, but they have the potential to slow down or even stop an agency from engaging in rulemaking if they feel we don't have the authority to go ahead with what we're proposing.
Okay, thank you.
Commissioner Ankers?
This isn't about the form itself, but more curiosity in terms of how we will move forward on the personal knowledge statement. And I think that the comment, the bullet, as you referenced it, that said we can only accept statements or complaints that are based on personal knowledge. Will this be evaluated primarily in the legal sufficiency stage? So staff will be making a recommendation on whether or not, through frankly your own subjective perspective, I'm thinking, they have adequate personal knowledge to have filed the complaint. And I can ask Mr. Schaefer or through the chair, the director.
We are currently working through sufficiencies that do fall under the requirements of the law. It is a part of the sufficiency analysis, and you'll see that addressed in there and in the compliance with the rules that you all adopted at the last meeting. So we're addressing whether or not that personal knowledge or information other than hearsay in accordance with the rules.
Will it be useful, I'm not encouraging data for the purposes of data collection only, but will it be useful to keep up with those that are rejected for legal sufficiency because of lack of personal knowledge?
Through the chair, we are doing that.
Thank you. Commissioner Law?
Thank you. You referred to adding a bullet about this personal knowledge thing, and I keep looking at this, what I think is the correct page here, and I'm not seeing that. Could you direct me to where that bullet is?
It is, if you look at page 6 of your meeting materials, that's the amended complaint form, the first page of it. If you look down to section 3, it's the second bullet point. It starts, please explain how you became aware of these facts.
So what I'm looking at doesn't seem to have bullet points, so I must be looking at
Here,
it.
I'm going to show you, Commissioner Watt. It's right there,
Excuse me, Commissioner Newton.
the second bullet in bold.
That's what I'm looking at,
Please.
but I like,
Oh, sorry.
thank you, Commissioner Ankers. So that's terrific. The other thing that I would ask is bring back the seal. There's plenty of room at the top of the page for this seal. So bring back the seal at the top of the page. And I don't think that would have to send it back anything. There's nothing terribly substantive about adding our great state of Florida's seal and our tagline about a public office is a public trust.
I can look to see if that would require a notice of a rulemaking change in the administrative register. If it does, it would slow down the rulemaking process, but if that's the will of the commission, I'd be able to investigate that. I can call over and see if that's the type of technical change that wouldn't require a notice of proposed change in the register, but it's not just a spelling error or something along those lines that we can probably correct on our own.
I call it letterhead.
Exactly.
Right. Well, just out of curiosity, what was the rationale for removing, I like that a public office is a public trust. I mean,
I'm not, that was a decision of our executive director.
Well, jumping in front of that train,
And that's why
I'm listening, I'm all for narrowing documents and I like the fact that sometimes the size of the packet or the material, you know, it's just,
I think this, as you might imagine with every work product that you eventually get to see, this goes through many hands. It started with me, and I think I took that out, but I can't remember why, and there isn't a legal or functional reason that occurred. So if it's the will of the commission, we can look into putting it back.
And if I can clarify, as long as it doesn't add more pages, I also, like the chair, love the fact that we're more condensed now. We've got the link to where all that background information is. I love that. But based on the ones I'm looking at, I think you got room for the seal. And I hope that doesn't slow down the rule. If that slows down the rulemaking process as being substantive, they need to re-examine that process.
I will say that even if it does, even if I call over to JAPSI and the department, I have to call JAPSI and I have to call the Department of State to make sure that we're comfortable with it. As long as you vote on the amended form today with that inclusion, it wouldn't slow it down to the point where I'd have to re-present it to you in December. I think I would just, at very most, have to publish the notice of change, then it might forestall this for a week or two, would be all that would be.
I would move the amended form with the seal.
so then, all right, so then just to make the record clear, we have a motion and a second to accept the recommendation with the inclusion of the seal and tagline, correct? All right, you have a first and a second. All those in favor?
Aye.
Any opposition? Hearing none, the motion passes unanimously. Thank you.
Save the seal.
We'll put it in Lynn's hands. She'll be our design list.
Mr. Shavy, I guess you can explain now Rule 34-8.
Yes, sir. Commissioners, this next rule hearing pertains to a series of rule amendments regarding material incorporated by reference in Chapter 34-8. Now, among other things, that particular rule chapter sets out and incorporates by reference the instructions for the Commission's financial disclosure forms. That would be the instructions for completing the Form 6, 6X and 6F, and the Form 1, 1X and 1F. Now, every year, we propose you with changes to kind of streamline those instructions, make them hopefully more accessible, make any updates we need to make because of changes in the law, and then we ask you to readopt them. And that's why we're here this morning. Thankfully, we don't have to overhaul these instructions as entirely today as we've had to in the past several years to account for electronic filing. But there are still several changes that we think need to be made. There are 7 of them. They are summarized in the memo provided for you in your meeting materials, but I'll just highlight them very quickly for you. Some of these changes, I will say, are not that significant. First, the introduction language for several of the forms talks about the maximum civil penalty that the Commission has the authority to impose if someone makes an error on a disclosure form, a complaint is filed about it, and then a violation is found. This would be, I guess, the penalty the Commission can recommend. The instructions list the ceiling on that recommended penalty as going up to $10,000, but last year the legislature raised that penalty limit to $20,000. So the first change is just to update the penalty ceiling to reflect that $20,000 figure. Second, if you remember earlier this year, you updated the instructions for the Form 6, 6X, and 6F to indicate that if a filer is an attorney, and if they have a client who would need to be reported and identified as a primary or secondary source of income on the disclosure form, they could just write legal client in the various disclosure fields without identifying the client by name. That's due to a rule in the Florida Bar concerning client confidentiality that could be triggered, and an attorney could be in violation of it if they identify their client by name on their form. Now, you have the authority to make that change to the income requirements in the Form 6. That authority is expressly given to you by the Florida Constitution. You did not, though, have the authority to make that change in the income instructions to the Form 1. But during this past legislative session, the legislature recognized what the commission was doing and amended the Form 1 law to indicate as well there that an attorney on a Form 1 can just write legal client in those fields as well without identifying the client by name. So we're proposing inserting language in the income instructions in the Form 1, 1X, and 1F to reflect that. We're using the same exact language that you approved earlier this year on the Form 6. Third, very simply, we need to update the calendar years in some of these instructions to reflect the 2024 calendar year. Fourth, in the training portion of the instructions, we need to add a position to the list of filers who have to complete that part of the form. And this is the part of the form where filers who are required by law to get 4 hours of ethics training each year indicate, they check the box to indicate they've gotten that training in during that year. Well, last year, the legislature passed a law stating that beginning in 2024, elected local officers of independent special districts and any person appointed into such a position has to receive those 4 hours of training as well. So they'll be subject to the training portion of the instructions when they start completing their 2024 financial disclosure, which will be next year. So we need to update the instructions, the list in the training section, just to add these kind of independent special district officers so that they know they're subject to that portion of the form. Fifth, we often get questions about how to value real property on the form. The instructions for the Form 6 indicate that real property should be valued at its market value for tax purposes. In other words, what the property could sell for. The Form 1 indicates real property should be valued at its most recently assessed value for tax purposes, which is a portion of market value, but isn't always the same. It seems valid to bring these instructions into alignment, and so we're proposing an update to the Form 1 filings to reflect that, just like on a Form 6, the value of real property should be its market value. And I believe that market value and assessed value can both be obtained from a property appraiser's website. 6, we'd like to correct a grammar error in the instructions in the Form 6 filings, just to correct a singular versus plural noun use. Probably that could have been a technical change, but as long as we're doing the more substantive changes, we decided to do that as well here. And then 7th, we'd like to add a footnote to the instructions for the Form 6 filings indicating that due to pending litigation, the Commission is currently enjoined from enforcing the Form 6 filing requirement against mayors and elected members of municipal governing bodies. Those individuals, during the pendency of the injunction, should file a Form 1. And once that litigation, if it's resolved in the next year, we're going to have to go back in and either remove or edit that particular footnote. If you have questions about any of these changes, I'd be glad to answer them. Just like before, these changes have been noticed in the Administrative Register, and they've been provided to JAPC. JAPC, again, has not had any feedback for us, which, again, is a good sign. So if you approve these changes today, the only step remaining will be to submit the amended instructions to the Department of State for adoption. I submit them to you now. I'm happy to answer your questions.
Any comments? Question? Go ahead, Commissioner.
Thank you. The reference to the value for real property, the proposed language is its market value for tax purposes. And as some of you know, I live in a world with a lot of taxes, estate taxes, gift taxes, and ad valorem taxes, which is the tax I think you're referring to here. Would it be, my request would be to consider adding ad valorem or county ad valorem, because the property tax record that I'm looking at is very clear. There is something on there called market value, but there's also market value for gift tax purposes, which is totally different. And so I'd like that clarification.
Is that
Through the chair,
something-
we could certainly do that. I believe that would require us to notice the change, notify JAPC of the change, and I think we have to wait 3 weeks from the date of the publication, notice a change before we could submit the rule packet then for adoption. So it would slow everything down by several weeks, but we certainly could add that.
Not wanting to slow things down, it sounded like at the beginning of the remarks that this is sort of an annual process, that you come back with these changes, if nothing else, to change the year, because I see we're going from 23 to 24. So I would be satisfied if staff would make a note to add that change for the next annual review of these and update of these, and what's another year with not being clear on which tax we're talking about.
Yeah, maybe 1 or 2 more hearings, that'll be all. But, yeah, I agree with Commissioner Lyle. I mean, you look at least back down in Dade County, you look at the tax appraisers, just on the property alone, there's a market value, and then there's a tax assessed value, and there's sometimes a difference. And, you know, although these forms need to be filled out with some due diligence, that could create some issues, but I agree. But so the motion right now is to accept the recommendations. You made a motion?
With the note to staff, yes,
With
sir.
the note to staff? All right, get a second?
Second, and I make a adjusting friendly amendment to name this the Commissioner Laird Lyle rule amendment, because thanks to his profile and courage, these changes are being made.
The here again, gone again, Laird Lyle.
Yes.
Right.
If you know, you know. If you don't, just,
okay,
you
too.
can
Yeah.
vote for the rule.
If you have to ask, it's not worth it. Yeah. So I have a first,
And I
second?
second it.
All right. All those in favor? Aye. Any opposition? Hearing none, the motion passes unanimously, with the staff note, of course.
Thank you.
Thank you. Miss Executive Director.
You don't have the reports?
After, no, the chair does not, I figured I'd skip that, but after I threw you under the bus earlier, Steve got in front of it, but
Good job.
you have the floor.
Okay, for the executive director report, just something I want to note. If everyone would please welcome Michael Terry. He is our newest staff attorney. He started at the end of September, and we're so thrilled to have him with us. He's already been a very productive member of staff, and we're enjoying getting to know him. So welcome, Michael, to the team.
Welcome, Mike.
And then also wanted to let you know, please join me in congratulating Amelia Naomi, who is now a full-fledged attorney with the commission and a member of the Florida Bar after passing her bar exam on the first attempt. I also want to note that all 3 of the legal interns the commission had the pleasure of working with. We're very proud team. Next up, with your approval, I will just talk briefly about the legislative report. We added that in there. Included with your materials is the memorandum outlining your priorities for the next legislative session. And we just want to put it in there. If there's any questions about those, otherwise that will be the packet that we provide to the committee members in the House and Senate for ethics as well as leadership and
Great. Any comments, questions?
I have questions about the litigation that's pending, and in particular, the litigation that the commission has been ordered to not enforce certain aspects of the reporting requirements against certain types of officials. So, and I know we have a portion of the executive director's written report referring to that. And so I don't know if she'd like to add something in verbally in this meeting, or if I should just base questions upon the record and the written portion of the report.
And, sorry, these are questions to the executive director?
Pardon me?
The question is directed at the executive director?
Yes, yeah.
Okay.
in terms of litigation?
And specifically, the one case that you and I have discussed extensively, and that your general counsel and deputy executive director have discussed extensively.
Yes, I'll go ahead and allow you to, we're happy to answer any questions you have, and I'll tee up Steve to be
Sure.
ready.
So the district court right now has the motions for summary judgment. But before receiving those, and we're waiting for the replies, I believe, to be filed by both parties. But before that, the court did enter its order granting the plaintiffs a preliminary injunction. And that was after our executive director sat through what she might characterize as a grueling deposition, because if you're a deponent, that's the only way you characterize a deposition, in which she gave, I thought, very appropriate answers to some of the questions. Some of them were challenging, but what I am concerned about is that we may be missing an opportunity to try and negotiate some changes that this commission and maybe the legislature would find appropriate to bring the reporting requirements closer in line to what I understand from the executive director's testimony would still be consistent with what the responsibilities of this commission are. And so my question is, have there been any discussions with respect to negotiating a resolution? And I'll start there.
And if I could just real quick interject this and defer to you, Steve, with respect to discussing an issue like that on a pending litigation in an open forum, if I can get some direction on that, I'm a little.
I would love you to get some direction on that. I've been told this is the right forum, which is
No,
why I
I'm
asked
not-
the
and I'm not
question,
saying-
but I want you to get the direction, so go right ahead, Mr. Chair.
I'm just,
So I work for all of you. I'm happy to answer any and all questions that you might have about litigation and about the discussions that we're having with our attorneys, Bill Stafford and Sarah Spears at the Attorney General's office, who are representing us in this matter. I get nervous when we start asking questions about strategy, obviously, because I don't necessarily want to, unless I'm being prompted to do so, I'm not necessarily eager to start talking about strategy in a public session like this. Obviously, the commission is, this agency is being sued in this matter, and you are right to have questions. We had a discussion about this. Maybe some of you were here when we had this discussion about the Garcia litigation, about having it in a public session or having it in a shade session. This shade was not necessarily available for that litigation. In that litigation, there wasn't the availability of a shade meeting. So I'm available to answer questions that you may have. I'm a little timid to answer as many questions as you might have, but I will do my best.
okay, just to follow up on that, and I apologize, Commissioner Lau, on an issue as this, would shade apply to this situation?
So the threshold question for getting into a shade meeting, so all public business has to be discussed in public, right? And that's as a result of the Sunshine Law. There's a carve-out for where our attorney is requesting direction on a matter having, in the litigation, having to do with settlement or litigation expenses. We've been, our attorney hasn't had any questions about that where we've been prompted to get into a shade meeting. If you all want to issue direction to our counsel, that would happen in the public if he's not asking.
Well,
Go
Yeah,
ahead,
and just to
Commissioner.
follow up, if I could, Mr. Chair, I mean, I think one of my frustrations is, from what I can tell from the minutes, our counsel has never gotten direction from us. And I don't know how a lawyer represents a client without getting direction from us. So I wish we would have our lawyer here to be able to have a dialogue with the lawyer in whatever public or private, it sounds like more private, closed at that point. But I would like to be able to understand some of the basis for litigation, the positions we're taking, and to see if we should be giving him direction.
Go ahead, Commissioner.
Is that work product?
One of the things
He
that
comes
you
up
all
with
have
these
done by
buzzwords
hiring
that are
me is
so
you've
on
hired
point.
an administrative
No,
attorney.
it's strategy.
No, it's a great
It's a
question.
product. I mean, we're putting out a product for the other side to see. Let me know.
I mean, that discussion, the discussion is not work product, but, the discussion, the way it's being proposed here would happen in a public session.
I get combobulated because we got a lot of attorneys up here and they want to litigate the litigation in the public.
I agree to a certain extent with Commissioner Lau, to the extent that the attorneys are representing us, the body, and we should have some type of direction, communication, or however, when the word settlement comes out, or instead of what we're doing, Plan B, which is perfectly fine, that doesn't fall under a shade session. It's not maybe the attorney asking, but it's the client asking, really, in essence, listen, let's talk about strategy. I don't think that should be done in a public forum.
So I'm Sure, if our attorney's not watching right now, I will make him aware of what's going on. And, he may end up having some questions now as a result of that. One of the things that in the absence of formal direction from this commission, one of the things that I have presumed that you would want us to do, since you approved the expenditure and you approved the recommendations that ultimately got adopted by the legislature, and that it was your will that these laws come to be, is that the litigation be defended under the presumption that that the law is valid, the law that you asked for is valid. And so we've been pursuing the litigation in that fashion. I've set the position with them that the law is presumptively valid. That's the course that we want to take. Our attorney has made the arguments, and we get to see those drafts as the arguments come through.
Right.
So that's the way that we've been proceeding. If there is, and we give you the reports on the updates in this executive director's report that you see every 6 weeks. Not just for this case, but for all the cases that we have. If there's something that you see where you want something to be discussed, we can have those discussions in a public session, or, and then that might prompt our attorney to ask questions and seek direction. And if it fits within the narrow exception of settlement negotiations or litigation expenses, then that would happen in the shade. But the way that we've been proceeding, and this has been even since before I became general counsel, is we update you through these reports, and if you want more input, then you obviously would let us know in the public session.
And I think that's what you're doing right now, right?
Well, it is, and with all due respect to the executive director's report, I don't think that you see in the director's executive report that we are losing this case. There's a preliminary injunction that was granted on an expedited basis that says this law is unconstitutional. And we can stay the course and we can try and fight this, but we are on a losing path today. And rather than lose completely, it seems to me like any litigant would, at this point in the juncture, want to sit down and talk about what the alternatives are. Because maybe there's a path to get this greater group reporting more information, if that's what this body thinks, in a way that is going to avoid the potential that seems to be the path right now, that at least at the district court level, we're going to lose this.
Well, and again, to Commissioner Howell's point, I don't tend to agree with the losing path, obviously, but notwithstanding, I think that those type of discussions with respect to settlement, if you can't get the whole pie, let's get a piece of the pie, that's definitely a settlement posture that should be done in a shade session, not in a public forum like this. To respect your position on it.
And let's be clear, I don't care whether this discussion is in the sunshine or in the shade. I just want to have the discussion, and I was told the only place on the agenda I could possibly raise this was the executive director's report, and that's where we are now.
Right.
Thank you.
Thank you. Go ahead, Commissioner Newton.
I'm just a little confused, because most of when we're being sued, all my capacity as a counsel and a representative, normally, we don't make that public because we're being sued. I don't understand if a member wants information, they can come to you and get that, correct?
Absolutely, and I think all of you are aware that you generally do.
Yeah.
A lot of you
Right.
do
But
call me.
I'm just taken back by, we never, if we had a situation where the body wanted to know and we couldn't meet outside of sunshine, we would go into an executive session or a shade session and do just that. They wanted to hash it out with the attorneys, but I never was on a body that did it in the public when we were being sued. That's the first for me. And you're always available. So, if a new member has any information or they got some strategy, I guess they can always call you, and your door's open for that. They can talk that, right?
So these are this is a constitutional challenge. This isn't like, for example, an employment discrimination case where there are money damages at stake. So money damages, litigation expenses, those types of things that's an easy gateway to get into the shade meeting. Some of that stuff is just not happening here. And so it's a little bit more difficult to get a case like this into the shade. As far as settlement negotiations go, I've been operating under the presumption that it's going to be very difficult to settle a case like this because it would necessarily mean compromising on
posture.
Essentially taking a step that we can't take, which is passing a law, because right now the law of the land is section 112.3144, which requires these individuals to file Form 6. We don't have the ability on our own to pass another law, so any settlement that we make necessarily involves an illusory promise that the fulfillment of which is outside of our control. So I've not really taken the posture that that's really on the table.
That brings me right back to where I started, work product and strategy. I mean, you hear words like we're losing and stuff like that. I mean, that's fine, but I'm just saying if a member wanted in-depth information from our attorney's attorney and our general counsel, they can get that at any time, correct?
And just real quick,
I
Commissioner
mean, our
Lyle?
audience with you for that information.
Yeah.
What I'm saying.
Everybody has my phone number and everybody calls me.
Thank you.
Go ahead.
Mr. Chair, if I can just respond to that, because I've had several conversations with our general counsel. He's very available, just as Commissioner Newton suggests. And I've had a discussion with our counsel at the Attorney General's office, and he was certainly cooperative. But what I can't have, other than in this room, in this setting, is a discussion with my other commissioners. And to suggest to the other commissioners that maybe there should be some approach other than this is the law. And I understand the general counsel's comment, and I appreciate that. I agree with it may be a difficult way to find a settlement. But I've never shied away from difficult, and I would expect my fellow commissioners are of the same mind, because that's why we're here. So I don't mind difficult, but what I want is the opportunity to discuss even what the possibilities are. Maybe it's a stay of the litigation to see if the legislature does change the law into something that the litigants would find. I don't know enough about these areas, but I just feel compelled to raise this and hopefully have this discussion. Thank you, Mr. Chair.
Is that a hand or?
So I'm a
Half a
professional
hand.
mediator, that's my day job. So what I hear from really our general counsel and Commissioner Lyle is it seems appropriate that if the attorney that represents the Ethics Commission can request a shade session to discuss settlement or strategy, then that would be reciprocal, that the client can request the attorney, even in a non-damages case. And what I think you're hearing is at least one member requesting that we have that discussion in confidence so that we may then determine whether or not it is appropriate to have settlement discussions. For the reasons you suggested, maybe we won't have that outcome, but we can't have that discussion without having the opportunity to do so in candor and with clarity. So I think that what Commissioner Lyle is asking for is and maybe to do it through motion would be the most clear way of requesting a shade meeting with our attorney.
Well, I'm aware of some Attorney General opinions where I think he will end up doing that on his own, based on the way that this discussion seems to be going. What I would be worried about is there are some Attorney General opinions that discuss doing an end run around him asking for it, and I do not want to put you in a position where you end up in a shade meeting where there are, again, the open meetings law is a statute with criminal consequences. I don't want to put you in that situation, so
Thank you.
yeah, so
I agree and trust that one will happen now through the very clear course of him hearing this, that he will request it. Now I'm curious about whether it's reciprocal. You don't have to answer that now.
Yeah.
But if the client can't ask the attorney for a meeting, then
Right.
again, I would say that is something also worth looking at, the why of that. But you don't have to answer that now, but I am interested. So I think you'll get your shade.
No,
And I would think that could be, because it will be a closed meeting, it could be something we can do remotely, hopefully by Zoom or some other way, so that we don't have to reconvene in person, and we don't have to delay until our next scheduled.
If while I agree, Commissioner, while I agree in principle, we may not agree on our positions, but while I agree in principle that, as a client, we should be able to, and again, with Commissioner Anchors, it should be reciprocated, but again, no opinion needed. Go ahead, Commissioner.
I can answer the why, and if I was general counsel, I'd be a little concerned with, I know it's the law, but we can do this around it when it's the law of the land.
We're not trying to.
I know, but that's been mentioned up here from this dais on the photo channel that we can get around that. And that's
No,
not
I don't
good.
think that that's what's happening here, but, you know, you can always request an audience with your attorney, and except in the narrow circumstance where the shade meeting exception applies, that audience occurs in the public, and that's not just this agency, that's every agency. I will also add, in the course of researching this, when this issue came up in the Garcia litigation, as Commissioner Akers, you might remember because you were here at the time, I talked with numerous board attorneys for other boards, and they often advise their counsels not to engage in the shade meeting, even when it is appropriate, because what ends up happening is it becomes difficult to police that conversation, and there are, again, because there's criminal liability attached to exceeding the bounds of a shade meeting, the board attorneys tend not to encourage the use of the shade meeting exception, even in that instance. So, all of that being said, I think we can get there. If you want an audience with your attorney for any other reason, we can do that in public session. I would say stay tuned to see what happens with settlement discussion. I think that, now that there seems to be some sort of an interest there, I believe that there will be some movement on that.
Okay, so for that, right now, we're waiting for can we make a request? Can this body make a request to speak to the attorney? But again,
Yeah,
based on the nature of the discussion, I think it fits squarely within.
Even the shade meeting would have to start in the public session, so
Okay.
I think that what you can request is I think it would be appropriate to have a public session meeting. It has to start in the
Correct,
public,
correct,
and then it
correct.
would transition to shade.
Right.
If he's looking for direction. So at least a motion for a public session meeting with our attorney would probably be the place to start, because that's the necessary predicate to getting in the shade anyway.
And just, can we tailor that notice for public session? Like, in other words, right, just for the purpose.
You can have a special meeting for that.
Right, for a special meeting, because I don't really want to get into the substance. As a matter of fact, that's today, I just feel uncomfortable in an forum. Just as an attorney, it's not comfortable.
I absolutely agree.
No,
So, but I was told there was no other place to bring it up, so
I
here we
understand, I
are.
understand.
Right.
So we have a motion then?
I'll be happy to make whatever motion you're envisioning.
Oh, this
So
is-
a move for a meeting.
Correct.
That will have to begin with a public meeting, a meeting in the sunshine, that would then presumably convert to a meeting in the shade if council so concludes that's correct.
Right.
And I would ask that meeting be able to be done in a remote setting so that we can be more timely and less inconvenience for all of us.
Any comments on that?
I have a question before there's a second. How do you have a remote meeting that is public? Can you do that?
Be two separate links that you would click on.
Okay.
And
Second.
that's funny, because in Robert's rule, you need a second to have a discussion. It's crazy. But anyways, on that, you mentioned the word criminal issues, and of course, that gets everybody's ears going. So with respect to the platform, it's going to be a Zoom call, is that what it is? I'm just wondering if they, or whatever platform it is, if they can guarantee privacy, because my understanding is there's an amount of expectation of non-privacy. I'm just wondering if they,
Those are logistics that I believe we've worked out,
Okay.
and we will continue to research that. And
Okay.
if
all right.
if
Just I don't wanna
logistics
get-
dictate a different outcome, we will manage to get you to where you want to be.
Okay. Via a video platform.
A video platform,
Okay.
yeah.
So as complicated as that is, I have a first and a second. All those in favor, say aye.
Aye.
Aye. Any opposition?
No,
One opposition. Right, the motion passes non-unanimously, sorry about that. All right, next up.
Before we
Yes, go ahead.
Chair, I noticed we have legislative report. I don't know if this is the right time to bring it up.
Yes, I was, before we circled back to executive director report, and so back to the legislative report that's in your materials, and I was going to make sure, I knew you had mentioned you might have something you'd want to talk about with that.
Again, I just noticed there appears to be a gap in the reporting requirements or the exceptions to the reporting requirements as it relates to gifts. There's an exception for family gifts for foster family is still my family today. But under the rule reporting requirements, I will be required to report any gifts received from my foster family, Christmas time or what have you. And it seems to me that there should be an exception for foster families as well. And I would certainly support any legislation that the commission may propose to allow that exception to be applied to foster families as well as biological families. Sorry? Not under the rules, there doesn't appear to be
Through the chair, the way that the legislative scheme currently works is the word relative in the gift law is defined as, and then there's about 30 or 40 different relationships listed in there. So all the predictable ones that you might expect, father, son, mother, daughter, all the steps, all the halves, and then it gets to things that you wouldn't necessarily consider to be a relative, like someone you are engaged to be married to or somebody you cohabitate with. And then that, you know, so there's these lists of very specific relationships that are defined in the definition of relative. A gift from a relative can always be accepted and never needs to be disclosed. But if in the case of a, let's say, foster parent, if a gift was received from a foster parent, that is not one of the defined relationships in the definition of relative.
And just out of curiosity, with respect to that, so as your foster parents, they were able to exercise legal control over you and execute documents for you, and so they're not your parents? I mean, I'm just, because I...
legally, they're my foster parents. They are not, I was not legally adopted by them.
Got you.
So they are not my adopted parents or my biological parents. They are my
Through a court order?
through the court.
Got it. Makes sense. It doesn't make sense why it wouldn't be in there, but it makes sense.
I was just going to move that we add to our legislative agenda the addition of foster relationships as we've been discussing, if that's an appropriate motion at this
Yeah,
time.
what's appropriate posture here, Steve?
Steve, are they able to take a vote on this
Oh, yeah.
under the legislative report without us having to schedule it for a future meeting?
Right.
If we might have
Yeah,
to
I
ask
think because
for
the legislative
public
report is
Right.
here,
on that?
it's on the agenda, it's an agenda item. They can vote to amend this report that is present.
It
here.
would be open to public input if
Public
there's
comment,
anybody
yeah.
here who wanted to speak on it.
All right, so
Public,
then
if there's
it
anybody
is
there.
proper here to entertain a motion like that?
Yes.
Is there anybody from the public that want to make a comment? Nobody. All right. So what's the motion?
The motion is to add to our legislative agenda the addition of the foster relationships for exceptions to the gift rules.
Second? All right. All in favor, say aye.
Aye.
Any opposition? Hearing none, the motion passes unanimously. Thank you.
Okay. Last item, and the one I know you just couldn't wait to talk about today, is your favorite e-filing report. You asked, and we deliver, so some stats are coming your way. The compliance rate so far for the 2023 form year as of yesterday for state filers is 97.86%. Local filers, we're at 95.67% compliance with 994 delinquent. So the total Form 1 compliance right now is at 96.56%. Form 6 compliance is at 99.35%. There are still 9 delinquent filers out of 1,384 non-judicial filers. The total number of expected filers is 37,194. So far, 35,915 have filed. That's 96.5% essentially, with 1,279 delinquent at this time. The fines are going to max out, those $25 a day fines, they're going to max out on November 2nd. And you'll note that the percentages and the total numbers changed a little bit from our last meeting as in terms of the raw number totals being higher with the percentages remaining somewhat consistent, and that's due to a data tweak with the system logic for our statistics. So at the last meeting, you asked me to give you some stats related to the call center and talk about that a little bit. I passed out some charts for you, and if you recall, just to sort of set the table, a year ago, we were facing a launch to nearly 40,000 filers with 0 customer service metrics. We did not know call volume or call duration. A vast majority of filers would be new to the system, with around 20,000 of those being local Form 1 filers who not only had previously filed on paper, but they filed with their local supervisor of elections. So we had no idea also about the call volume to local supervisors of elections or the amount of time they spent assisting filers. So in terms of the call center, we had to take an educated guess as to how much staffing we would need to avoid a customer service catastrophe of long wait times and filers not being able to receive timely assistance with their filings. As you know, you approved a contract with Alight, now known as Strata, for staffing of 10 call center reps and a call center manager to handle Form 1 calls. The Form 6 calls and coordinator calls were to go to the commission. And now we know that the call center received 8,843 calls during the call season, disclosure season, and they made 3,216 outgoing calls between April 28th through September 19th. That's on your first page of the charts that you'll have. You'll note from the data on the second page of the call stats that callers experienced less than 30 seconds of hold time before their call was answered, even during the busiest week. So that's on page 2. The average handle time for the call center reps ranged from about 7 minutes and 5 seconds to about 9 minutes and 8 seconds. You'll see those times reflected on page 3 of the stats. I'll note that COE staff is very jealous of that call resolution time because we handled the escalated calls, and some of those calls took an hour. So of the calls handled by the call center, our ticketing system reflects that roughly 10% of the calls, 10 to 12% on average, were escalated to the commission, and escalation information can be found on pages 4 and 5 of your statistics. Our heaviest call center week was the week of June 23rd, with 1,253 calls. Mondays were, of course, our heaviest call days during filing season, just like the doctor's office. We don't find that surprising. We could also see spikes in different days following reminder mailers or emails that we sent in an effort to get the attention of those filers who might have missed or even ignored our emails, thinking that financial disclosure didn't apply to them. I will note that you will see we had this call center doing reminder calls. We've had a handful of individuals complain that our reminders bordered on harassment. We're just trying to get them to comply. Keep in mind, individuals who file their form are not sent the reminders, but the law requires weekly email reminders to non-filers until the grace period runs out and the fines cap at $1,500. So call numbers rise and then fall sharply in a short period of time. And when those numbers fell, we utilized the call center's representatives to make reminder calls to filers. They made 3,197 total reminder calls. This meant that our staff did not have to do what we lovingly refer to as phone fun day, when every single member of our staff spends an entire day calling those who have not filed. And I can tell you, we've never hit 3,000 calls. Utilizing the call.
That's the harassment part, right?
Just begging people to comply with the law so we don't have to fine them. Utilizing the call center reps for this task was much more efficient and allowed for multiple attempts to connect with those who had not yet filed. I also decreased the number of call center representatives on August 26th from 10 call center representatives to 4, given the lower incoming call volume. So if you look at page 5, we've outlined total incoming calls to the commission during filing season. You'll note that talking to staff remains the hottest ticket in town during disclosure season. Our office call counts are, as you recall, for incoming calls. We know that the number of calls that were transferred to the call center exceeded 8,000. Those folks immediately self-selected through the call tree to transfer due to those prompts. Other calls to the commission were Form 6 questions, opinions, complaints, disclosure coordinators, or escalated Form 1 questions that could not be resolved by call center staff, and always filers who bypass speaking to the call center. Our busiest month was June, for example. We had 9,229 incoming calls to the Commission on Ethics. Of those, during the month of June, 4,120 went to the call center. There is no way the Commission staff could have staffed and managed the call volume without the assistance of the call center. We were short-staffed on attorneys. The support staff stayed extremely busy on the phones. Also, of course, the financial disclosure staff worked long hours handling escalation tickets, handling redactions and emails throughout the season. There was a significant risk for us and the call center, given the unknowns. Given our experience this year, we now know a lot more information than we did last year. You approved $533,800 for the contract. We began training call center representatives on April 22nd, and the contract ended September 19th. We've been billed a total of $361,000 so far. I'm awaiting the August and September invoices, but I anticipate the final total will come in at $486,664, which is less than the amount that you approved. We were very pleased with Alight, which is now Strata. They accepted all of the unknowns with us and jumped in the deep end this year. They were very responsive. They were easy to work with. And although we could renew with them, the plan at this time is to utilize the metrics that we now have and the knowledge we have to ultimately put out a request for quote, given particular assumptions and variables to make sure that we provide the best value for the taxpayers and the best service for the filers and the commission. And once again, once that packet is ready, it'll come before you for your consideration, because thankfully my expenditure authority is limited to $10,000. And I'm happy to answer any of questions that you have. Otherwise, that concludes my report.
Yes, Commissioner.
The 4 to 5% return rate on the Form 6, is that in line with what we were doing on paper?
In terms of the compliance rate?
No, versus online versus paper.
The compliance
Is that about the
rate
same?
for Form 6 is very, very close to what it was last year.
paper.
Probably
Yeah.
within 1 or 2 filers
My
of last year's compliance. So Form 6 compliance is very high. And remember, Form 6 filers filed electronically last year as well. So this is their second year. We did see a decrease in calls from Form 6 filers, or at least less complicated calls. We're hoping that next year, now that everybody, all the Form 1 folks have been doing online filing this year, that the calls will also decrease.
Well, I was trying to look at the percentage I know we had 96 versus when we did paper. I was trying to go paper.
I beg your pardon. We're running about 2% lower compliance this year than last year for Form 1 overall. I wish it were the same as last year. It's not surprising to me that it's lower because it is the first year of electronic filing. We're going back through now, working through email issues in terms of coordinators who maybe, the system would not accept a list of filers from a coordinator without having email addresses for all of them. And when push came to shove, I think sometimes email addresses were put in that were maybe an unknown at, where we couldn't get notice to someone. So we're working through those emails to determine if we can find better emails and get folks to ultimately comply. Of course, you will be seeing appeals from individuals once we,
We would never make up Gmail to get a.
you know,
Lastly, this is a good report. The money that we allocated, that was already budgeted, was it enough, and did we have any left over, was it all spent?
we came in under the contract amount on this, and you'll recall you approved that to come from carry-forward funds, so we're only spending out what they're billing for, the hours that they're actually billing for. We pulled down the number, we lowered the number of call center representatives, and so that also helped us come in under.
Yeah, I thought that was great. As we went into it, it didn't need them, you were amping down.
Correct.
But it was money well spent. I think it did what we needed to do. Thank you.
Any other comments?
I thought it was a great report. I didn't see on here the number of incoming calls asking for political contributions or trying to sell prescription drugs. So, nice job.
Thank you.
Any other comments? At this time?
Not on this report, but before we leave the executive director, could I raise one more question?
That's what it said.
Yeah, go ahead. That's what we're
I
here
work
for.
for you, yes.
Thank you. So, and this goes back to a discussion we had earlier today. It seems to me like I would like to have staff make a recommendation to us about about what our rules on reconsidering decisions should be. And that recommendation might be that we should not allow reconsiderations at all. But if the decision is we should allow reconsiderations, I would expect timing issues consistent with Commissioner Anker's questions, a clear standard of proof, if you will. And so knowing that our public meeting agenda is about to come to a conclusion, it seemed like this would be a good time for me to make that request, whether it's of the executive director, whether it needs to come from the chair, but that would be my request.
No, and just to echo that, Steve, we had this discussion. I mean, I agree 100%. I mean, one thing is, not having something versus having something, having a standard to go against, which is what we're all used to doing. So we can get back to us on that.
Yes, if it's the will of the commission, we'd be happy to look at that, devise something, and then bring it before you.
Yeah, only because of the recent changes to the statute as well, that could, so, again, thank you. Right.
I think that would serve to be a great model for what we're going to do here.
My best love of practicing.
And I would be open-minded about having no authority to reconsider at all. I mean, because that is another possibility. I just want to have a rule within that we can point to be able to tell respondents what the rule is.
Sounds good. We can have it, I mean, when it's presented to us, we can have the discussion, tweak it.
Yes, sir.
All right? Anything else?
Do we need a motion on that?
No, that's
I think I'm clear.
We understand it.
You're good?
Yes.
We know how to get a hold of them.
We can't reconsider it, though.
But I would like a motion to adjourn. Second.